Hello, welcome to this screencast on how to plan questions on contract formation. Let's look at the learning outcomes for this session. So hopefully at the end of the screencast then you should be able to explain the method needed to plan problem questions on offer and acceptance. You should be able to identify key rules concerning offer and acceptance in the context of a problem-style question. And finally, you should be able to explain what is meant by applying the law to the facts of the problem. This is the process through which you relate your legal knowledge to the circumstances of the scenario that you're presented with in order to provide concrete legal advice to one or more of the parties as directed by the question. Righto, well, let's start off by looking at a very simple offer and acceptance problem question. The one I've presented here is a good deal simpler than you would see in an examination, but it's presented just to get you into the habit of breaking down a set of facts and analysing each event in strict chronological order, as we'll see in a minute. So let's just read through the problem question together. We're told that Claudia noticed an advert placed by Anna in her local paper for the sale of a KitchenAid food mixer, as good as new, at £200. Realising this was a good offer, these mixers are sold new for £450. Claudia posted a letter to the address provided saying that she would buy the mixer for the advertised price. The letter was lost in the post and never arrived. Claudia, having heard nothing for several days, called in person at Anna's address to ask whether her letter had been received, only to find that the food mixer had been sold to someone else. And then you're told to advise Claudia. Right, so let's have a look then at how to plan problem questions on contract formation. Now, the very first thing you should do is read back through the facts of the problem and then arrange each event as it takes place in strict chronological order. And you could do this perhaps on a separate piece of paper using bullet points, or you could use a table, which is what I've done. I'll show that in just a moment. Now, having arranged the events one by one, what happened first, what happened after that, etc., etc., you need to go back through the events from the start in order to work out the legal significance of each one. These are effectively the legal issues that you'll need to explore in order to provide a full analysis of the problem question. Now, there are a number of possibilities, but in fact the first issue to arise is always whether someone has made an offer or are the parties simply still at the invitation to treat stage? In other words, are they at the pre-negotiation stage? Now, if you think that an offer has been made, in other words, if you think that one of the parties has clearly expressed a willingness to enter into a contract on specific terms with the expectation that if the other party is agreeable, a contract will come into existence, well, the next issue may be, depending on the circumstances, whether that offer has lapsed in any way, whether the offer has terminated. Now, you'll remember from the lecture that there are a number of ways in which an offer can come to an end. An offer once made doesn't remain on the table forever. So, for example, there may be termination due to revocation or withdrawal of the offer by the offeror. There may be an express rejection of the offer by the offeree. There may be something called a counter-offer, in other words, where the offeree tries to introduce new terms or vary the terms of the offer. An offer may lapse through time. We also had a look at the rules concerning the effect of the death of one of the parties before the acceptance takes place, and indeed also we looked at the occurrence of terminating conditions. Okay, and probably the final key issue is going to be whether, assuming an offer has been made, has that offer been accepted, assuming that the offer is still on the table at the relevant time. Just one point to bear in mind here, you may find that the facts of a problem question have been kept deliberately ambiguous, or the examiner or the person who wrote the question may have deliberately withheld a vital or key piece of information, so that you can't be sure of the contractual significance of one or more events. If that's the case, you may be in a position where you have to discuss different possibilities. Okay, more on that a bit later. So, as you analyse the contractual significance of each event within your chronology, you're going to have to quote the relevant legal rules that will help you resolve each issue you've identified, as well as the names of the cases in which these rules were either established or applied. Also, don't forget here to learn, quote, and apply key definitions such as what is an offer, what's an invitation to treat, what's a counter offer, what's an acceptance, what's a request for information. These key definitions are effectively legal rules, and you can use them to help you predict the likely, as I say, contractual significance of each event as you go through your list. So, having quoted the law, it's now a question of applying, in other words, relating the relevant legal rules to the facts of the scenario. And it's really important here that you give reasons for your conclusions in relation to the rules that you've mentioned. So, for example, if you think someone has made an offer, you need to say exactly why this is. An offer, remember, is a clear expression of willingness to enter into a contract on specific terms. So, why has an offer been made? Were the terms specific? Did someone put forward a firm proposal, for example, to sell a specific item at a specific price, with the expectation that if the other party were agreeable, a contract would come into existence? So your reasoning is really important. It's the bit that students often miss out. Sometimes students think that the reasoning is so obvious that it goes without saying. But the reasoning represents your application of the law to the facts, for which there are substantial marks available in the context of a problem question. Just one last point. Remember that when you're discussing whether an offer has taken place, or indeed whether an acceptance of that offer has occurred, you may have to consider two things. First of all, the content of the exchange, but also secondly, whether the relevant communication rules have been complied with. So, in relation to an offer, as we've seen, you've got to determine then whether someone made a clear expression of willingness to enter into a contract on specific terms, etc., etc. So that's one requirement. But of course, remember also that offers, to be effective, have to be communicated or notified to the offeree. In other words, it's not possible to accept an offer that you know nothing about. Okay, so once you've been through the planning process, it's then a question of writing up your answer. And always start an offer and acceptance question by saying in your introduction that the seller will only have to go through with a sale to the buyer if a legally binding contract has come into existence. Now, here it might be worth briefly defining what a contract is. In other words, it's a legally enforceable agreement. And just briefly state the elements of a legally binding contract. We need an offer, an acceptance, an intention to create legal relations on the part of both parties, and consideration, again, on the part of both parties. It would also be worth just briefly explaining the objective approach. In other words, when the court is trying to determine whether an offer and acceptance have taken place, it's not a question of what the parties themselves actually thought, it's a question of what a reasonable onlooker would have understood according to everything that was said and done by the parties. Okay, well, let's briefly review the offer and acceptance scenario that I introduced earlier on. You might just want to briefly pause this screencast just to remind yourself of the facts. Now, remember that the first thing to do is to go back through the facts of the problem question and arrange them in strict chronological order. And I've done this on the next slide using a table. And you can see here that I've arranged the events in chronological order and left myself a space to identify the legal issues that arise at each stage. In other words, what is the contractual significance of each of those events? Now, taking the first event, this is where Claudia sees the advert placed by Anna in the newspaper for a food mixer, quoting a price of £200. Now, remember, the first issue is always whether an offer has been made, or are we simply at the pre-negotiation stage? So the first issue then is whether the advert is either an offer or an invitation to treat. Now, this is the point where many students will dive straight into the case law specifically pertaining to adverts. But before you get to that point, there's a bit of groundwork to lay down. And in relation to discussing the law fully here, you would need at this point to define what an offer is, as I mentioned earlier on, and also define what an invitation to treat is. And having quoted those definitions, then would be the point at which to state the specific rule concerning adverts. In other words, adverts are usually simply invitations to treat. Cases like Partridge and Crittenden are authority for that proposition. And unless the advert contains a very specific unilateral offer, so as to bring it within the Carlyle and Carbolic Smokeball Company exception, the advert, as stated before, will simply be regarded as an invitation to treat. Of course, invitations cannot be accepted so as to bring about a legally binding contract. Righto, well, next we're told that Claudia wrote a letter to Anna saying that she would like to buy the mixer for £200. Now, we're confronted with exactly the same issue again as before here. Is this an offer or is it simply an invitation to treat? Now, we've already discussed the law on that point, so you don't need to repeat what you've already said. There is, however, one further aspect here which actually arises at the next stage in the chronology, which you could mention at this point, and that's, of course, the need for communication of the offer. And again, you would perhaps quote cases such as Williams and Carradine on that particular point. Now, applying the law to what Claudia has written, it does appear that the content of her letter has the quality about it necessary to amount to an offer. This does appear to be a clear expression of willingness to buy a specific item for a specific price. So Claudia's letter then appears to contain specific terms, presumably with the expectation that if Anna is agreeable, a contract for the food mixer will come into existence. So concluding there then, it appears that the content of the letter is potentially an offer. However, of course, at stage 3, we're told that the letter was then lost in the post. And jumping here straight to the application, we can see here that the offer was never communicated to Anna. So, in fact, legally, there never was an offer. Claudia never made an offer, and so there can be no contract here. Now, at the very final stage, we're told that Claudia called at Anna's house in person, but was informed that the mixer had already been sold. Now, we can't be quite sure of the way in which the conversation developed here, but even if Claudia repeated the content of her letter and told Anna that she was interested in buying the food mixer for the £200 asking price, all that Claudia would be doing here would be making an offer. And Anna's response that she had already sold the mixer to someone else clearly could not amount to the acceptance of any such offer. So, hopefully then that gives you an indication as to how to break down the facts of an offer and acceptance question and how to analyse each event so as to maximise your marking potential. What I'd like you to do now is read through the suggested answer to this question, and that should illustrate what a really good answer would look like in practice. Okay, well, thank you for listening to this screencast. I hope you found it useful.